If you're worried if your child's inheritance could disappear in a divorce, you're right to be. Without the right protections in place, a divorce settlement is going to come after half of the inheritance that your child receives. Which means that if your child goes through a divorce, they're not only breaking up their family, they're dealing with the financial loss of losing half of the assets you spent your entire life working for just to pass down to them and take care of the family. I'm going to show you exactly how to structure a trust so that you can make sure the inheritance you're passing down to your child is protected from any future potential divorce settlements. Here's how quickly their inheritance could vanish during a divorce settlement. Let's say you give them $500,000 and they invest that money. Over a 5-year period, it grows to $700,000 and they go through a divorce settlement. That divorce settlement could take $350,000 that they grew to $700,000. This does not just apply to cash. This applies to your family home, vacation homes, rental properties, a business, stock accounts, etc. The courts will value all of these assets, split them in half, and distribute them between the spouses, which means that half of the assets you worked your entire life to build up and take care of your family gets wiped out in one divorce settlement. If you want help setting up asset protection for your child's inheritance so it does not get taken in a divorce settlement, click the link in the bio, fill out the form, and schedule a time to talk to someone on our team. Here's a myth that people believe about separate property, so that they believe that inheritance is automatically separate property and it's not going to get split up in a divorce settlement. Now, it is separate property automatically, but the problem is going to be if you commingle money, use that money to pay for things like the mortgage, utilities, etc. for the benefit of the marriage, or you retitle property into the name of you and the spouse, it becomes marital property and the judge could split it up in a divorce settlement. And the problem is going to be it's not on the ex-spouse to prove that it's marital property. It's up to your child to prove that it was not marital property. They have to fully separate all of the assets and the money. They have to keep up with all of the accounting related to it, and they will have the burden of proof if it comes to a divorce settlement to prove that that inheritance is separate property. Let's go over the 3 steps on how you can protect your assets so that your child's potential divorce in the future does not take their inheritance. The first one's going to be setting up your revocable trust. While you're alive, you have full control over the assets inside of that revocable trust, but when you pass away, the trust turns irrevocable and you can leave the assets inside of that trust instead of fully distributing those assets out to your children. That way the trust owns those assets, your child does not own those assets, which means that when the divorce settlement is coming after the assets that they own as marital property, the assets inside the trust are not part of the assets that can be distributed in that divorce settlement. The second thing we need to do is set up conditional distributions for this trust. The typical way that people are going to distribute assets out to their children is in a lump sum when they pass away. So they just give all the assets to their kids at the point of them passing. Conditional distributions from the trust are going to be when certain conditions are met, you will make those distributions out to your kids. Some examples of these are going to be age-based distributions. Let's say you give out a third of the assets that you have when they turn 30, when they turn 40, and when they turn 50. Other examples are event-based distributions when they graduate college, get married, have health care issues that they need help paying for, or they have retirement that they are going into. Because your child does not have access to the principal of the assets inside of that trust, it's not something that can be split in that divorce settlement. Another added layer that you can do is have the trustee have discretionary distributions out to your kids. So instead of giving set distributions out to your kids like a monthly allowance or an annual allowance, what you can do is give the trustee the discretion as to when and when not to make distributions out to your kids. The benefit of this is going to be that the judge cannot make the distributions from your trust be able to be captured for alimony or child support payments. The third thing that we can do to give extra protection is choose an independent trustee. So the mistake that a lot of parents are going to make is they will make their children the trustee of the trust, which gives them full control over the assets inside that trust. The risk here is that the judge could say your child has constructive ownership over the assets inside that trust via that full control over those assets, which means that they could take those assets and split them up in that divorce settlement. So instead of making your child the trustee of the assets inside of that trust, what you could do is pick an independent third party, which would be a professional like a trust attorney, to manage the assets and distribute those assets out of the trust. That will give a layer of protection from the judge being able to capture the assets inside of that trust, because your child is not going to be in control of those assets inside the trust. Now, if you want help setting up asset protection so that your child's inheritance does not get captured in a potential future divorce, click link in the bio, fill out the form, and schedule a time to talk to someone on our team.